All right, the next case on the docket is Wayne versus EINSPAR. All right, we're ready when you're ready.
Good morning, Your Honors. May it please the Court, Richard Feinberg for the appellant, Matthew Wayne. Matthew Wayne is seated behind me in the second row on the side of the courtroom. This appeal involves a final judgment.
Before we get into the substance of the appeal, Mr. Feinberg.
Yes, sir.
I noticed that at one point you moved to strike a brief that opposing counsel filed, correct?
We did.
And that's because it was not compliant with a court order?
It was not timely filed.
In response to a court order?
Correct.
Now, you filed a motion to enlarge the page limits of your brief, is that correct?
We did.
And we entered a court order on that, correct?
Yes, sir.
And what did that court order do? What did it allow?
The court order enlarged the number of pages for the brief.
From to what?
I don't recall the exact number of the pages.
Well, that's kind of what I'm getting to here. You asked for a certain number of pages, and you don't remember what they were.
In preparing for oral argument this morning, no, I did not go back and look.
Well, I'm going to tell you that your brief violated the court order by exceeding the page limits that you requested.
I do recall that it exceeded it by some number less than 5.
No, it was a number greater than 5,
Okay.
and that's in violation of a court order, correct?
Technically, it would be, yes.
Nothing technical. It's
Yes.
the same, you know, if they're not following court orders, you're not following court orders. What about the font size on your reply brief? Was it in compliance with our rules?
I trust that it was.
Well, then you would trust inaccurately. So if you're going to, and of course you got away with it because your opposing counsel didn't move to strike the brief, and if we had picked up on it a little earlier, once we start preparing this case for oral argument, it's a little late to start striking your brief. But if it occurs again, Mr. Feinberg, and I'm on the panel, just fair warning to you, I'm going to strike your brief as you're walking from that table to that podium.
I understand that.
You got extra pages on a dissolution of marriage case. We've got a securities case coming up later this morning. They were able to, and there were 38 million reasons for them to have an extension of for their briefs, and they got it done in 50 pages. There's no reason you couldn't have got it done. So let's go ahead and get to the substance now. But when we enter an order, particularly when we give you what you ask for, you don't get more than that. Do you understand?
Understood.
Okay, thank you, sir.
Okay. May it please the Court, this case involves the appeal of a final judgment.
Let me get to some preliminary matters, and I think it'll
Yes,
clear
sir.
some confusion up with me, perhaps. And it has to do with your allegation that there wasn't proper credit given. I think it was $1,500 per month towards the alimony payment.
Correct.
And I think there may be some, confusion as to exactly how many months we're talking about. Can you tell me how many months we're talking about?
There was confusion in the testimony. Actually, the bank records that were placed in evidence in the joint trial exhibit notebook indicated that the $1,500 per month payment began in April.
For how many months, though?
The bank records indicate 12 months. The testimony would indicate 11 months.
Okay.
So that's the difference.
Okay, so we're talking about, according to your your best estimate, anywhere from 11 to 12 months, and it's $1,500.
Yes, sir. It's either $18,000 or $16,500 that was not credited in the court's final judgment, and there was no
And
testimony.
then the child student loans and the car loans, how much are we talking about there?
Excuse me, Your Honor, I just want to step aside and grab it.
Okay.
The testimony at the trial court level was that the payments were made on the student loan during the pendency.
Can you just give me a final figure as to how much money we're talking about here?
I can't quantify the amounts that were paid on the student loan and the amounts that were paid on the auto loan were monthly payments of approximately $200 to $300 per month for the pendency of the case.
I'm sorry, for what?
During the pendency of the case. The case was filed in July or August.
So the payments that we're talking about is something like $200 a month total?
$200 to $300 per month for each that were paid during the case, and then there was still resulting balances owed on the student loan and the auto loan at the conclusion of the testimony in July of 2014.
You don't have a total figure for me for that?
No, sir. I didn't do the math preparing for oral argument. I thought the point was that these were marital liabilities that should have been identified by the trial court under 61075 that were not. And the same reason that the trial court awarded credits for the payment primarily of the party's Minnesota property during the pendency of the case, credit should have been awarded for the payment of those liabilities as well.
And who were the parties to the car loan and who were the parties to the student loan?
One of the parties, either the husband or the wife, was party to the student loan, and either the husband or the wife was parties to the automobile loan. I do not recall at this moment which party was on which loan, but the husband was on one of the loans, the wife was on the other loan. They were secured well before the filing of the petition, during the party's marriage for the party's son. May I proceed? The first point that I would like to get to, Your Honor, is the failure to exclude...
Just to clarify, I think Mr. Wayne was on the car loan and Ms. EINSPAR was on the co-signed on the student loans.
Okay, very well. And I cited in my brief the Wagner case, which was a case very different than this, but the same applicable principle of law, where the husband in the Wagner matter, and that was out of the 2nd District, literally 4 days before he filed the petition for dissolution, put the child's student tuition of some $13,000 or $14,000 on a Discover card, then 3 or 4 days later filed the petition. The wife challenged whether or not that was a marital obligation, whether or not it should have been identified and distributed, and it was. And in this case, we don't have any of those types of shenanigans where these loans incurred days before the filing. These were well before these parties even separated.
If you had to pick your most important issue for purposes of this appeal, I know you raised, 10 issues.
I did.
Which gives you 2 minutes per, issue.
Very challenging.
So what's your most important issue that you think warrants relief?
The most important issue is probably one of the most garden variety ones, the failure to impute income to the wife in this matter.
And why don't we talk about that?
There were days of testimony in this matter from 2 different experts, a Mr. Galt and a Ms. Fernandez. Mr. Galt was hired on behalf of the husband.
Right, but didn't the trial judge reject Galt's testimony?
The trial judge found it was not helpful, yes, and that's clearly...
And isn't that within the purview of the trial judge?
It is, but the trial judge has to explain in her judgment why it wasn't helpful or why it wasn't creditable and why it was rejected, and I don't feel the trial judge did that in this matter.
Well, there was conflicting testimony from 2 experts, correct?
No, not necessarily. Ms. Fernandez, who was hired by the wife in this matter, never addressed anything outside of Brevard County, and she never addressed anything in the state of Minnesota. Mr. Galt did an exhaustive statewide analysis in the entire state of Florida, and also did a very exhaustive analysis.
Well, you got, here you have, I think, I'm not sure I have the age right, but around 56 in that area, maybe 56, 57 for the wife at the time of the trial. And during the course of the marriage, she stays home primarily and takes care of the children.
I take issue with that. This was a 20-year trial lawyer who was also a due process hearing
But
officer.
she didn't practice law for most of the marriage.
She practiced law for the first 7 or 8 years of the marriage in a full-time capacity, and then practiced less, but also worked as a due process hearing officer for the school board of Chicago.
And she went, the husband had a series of jobs, and they moved around, and she assisted him, with his career, which was certainly much more successful in terms of remuneration than hers, correct?
There's no question that during most of the intact marriage, the husband was the primary wage earner in the family. After the first
But then
7
now,
years.
he finds, a new girlfriend, and so he files for divorce, and so she's now supposed to change what she's been doing for the majority of the marriage and alter her employment status accordingly. That's effectively your position, is it not?
Well, I think divorce changes both parties' lives, and I think the law says
Well,
that.
but you don't, you don't have your spouse, and he consents to it during the course of the marriage, you have a certain course, and when the trial judge rejects, your argument that this income should be imputed, that's an abuse of discretion in your mind? No other trial judge would do that?
Based upon the fact that the wife in this matter was a licensed attorney in 3 states.
Was it an abuse of discretion?
I believe it was.
Right, why?
Because this is not a person with a bachelor's degree in sociology, and the husband is taking the position that she ought to go out and earn $75,000 or $80,000 or $100,000 a year. This is a person who had been licensed to practice law since approximately 1984, was licensed in Illinois, licensed in Florida, licensed in Minnesota, did so well when she took the Florida bar in 2010, and the testimony from the wife was that she took the bar in 2010 because she wanted to return to meaningful legal employment. One of the exhibits in the case was a letter that she wrote, the wife wrote, to a fellow named Mr. Cohn. I believe his name was Matt Cohn. He was up in Chicago, and she wrote to him and said, "Dear Matt, I want to return to the practice of law. I want to return to meaningful retirement. Is there anything that you have available for me in your area of the law?" At the same time, she's taking the Florida bar. She passed the bar, and she did well enough on the bar exam to be grandfathered in to the state of Minnesota without having to take that exam. This was a lady who, besides being licensed in 3 states, was licensed in the federal courts of Illinois, the United States Supreme Court, had argued in the federal courts of Illinois.
And who's
was
50, whatever, 56, 57, whatever, years of age, and you think that that is going to be attractive to law firms, that they're going to just jump at the chance to hire a lawyer at that age, and with the fact that she hadn't effectively been practicing law for years?
I would acknowledge that she hadn't practiced law for several years, approximately 8, as of the time the trial began. However, age discrimination is illegal, sex discrimination is illegal. I'm 60 years old, still practicing law, and Mr. Galt took that into consideration when he offered his opinions. He didn't come in and say, this is a person practicing law for the last 20 years. He came in and said, this is someone with 20 years of experience. And if you look at all of the exhibits that were entered in this trial, that were authored by the wife in this matter, all of her resumes, she says, I'm a lawyer with 20 years of experience. I'm published in the federal courts. I'm a due process hearing officer. And if you look at those resumes, you will find that her resumes actually corroborate Mr. Galt's testimony.
And was there evidence that she had attempted to find jobs and was unsuccessful in doing so?
There was evidence that Ms. EINSPAR never looked for a job in the legal field since this matter was filed in July or August of 2011. She testified to that. She said, I never looked for a legal job. What did she do? She took a part-time job with the Brevard County Guardian ad litem's office for $14 an hour, part-time. Didn't work full-time, part-time. Then took a job in October or November of 2013 back at Pacer in Minnesota when she moved back to Minneapolis. But the testimony in the record was that she never looked for a job in the legal field. Mr. Galt.
The trial judge made the following observation, reference Galt. She said that for the jobs he mentioned, he being Galt, was not aware of the job requirements needed. Was that correct?
I think that Mr. Galt offered significant testimony in this record about...
Is that correct or not?
I believe it's incorrect.
Okay. Now, you're at 5 minutes. You're also going to have, the cross appeal to deal with.
We'll reserve 5 for rebuttal and deal with the cross appeal at that time, Your Honor.
All right. Then we'll stop you now and let's turn it over.
Good morning.
And are you going to want some rebuttal on the after the cross appeal?
Judge, based on your schedule this morning, I think I'll just do all of mine at the same time.
All right. Very good.
Good morning again. My name is Mark Peters. I represent the former wife, who's the appellee and cross appellee in this case.
Mr. Peters, let me start, with an issue, that the appellants raised in terms of whether, we got these 3 disability policies, and one of them terminates, I think, in a couple of years. I think it's 61. The other might be 65. The years aren't really significant to my question. The issue raised is whether, because we know at the time of the dissolution that these policies are going to terminate, whether therefore it's not subject to modification at the time that in fact these policies end. What's your response to that?
I don't think that's any more accurate than we know that at some point people retire. We understand that issue when we try a case, and we know that there are...
So you are, on behalf of your client, not taking the position that that would not be modifiable?
I would agree on behalf of my client that at the time that these policies term out, that event would be a substantial change in circumstance from when we tried this case.
But isn't one of the elements on modification also that it wasn't contemplated at the time of the initial award?
And I struggle with the rationality behind that, because we know there are certain things that are going to happen prospectively in the future in everyone's life. I mean, you could argue that was the case in every permanent alimony case, that we know at 65 I'm going to retire, and therefore I can't use retirement.
You may know that at some point somebody's going to retire. It's not certain when or what the consequences of the retirement are. It's a little different in this case when you know absolutely that on a date certain the income is going to drop by X dollars. Isn't that a difference?
It is a difference. I mean, in the Hollingsworth or Hollinger case, we had an issue in that case that was cited in our brief that we knew that there was a contractual end to certain income and the spouse was receiving in that case. And that was not the basis for the court to do durational alimony or term alimony or change it at a certain date. Because even though we knew that contract was going to end, the trial court is supposed to focus in on what was going on at the time of trial. What is the income and assets of the parties at the time of trial? Can you imagine the issues we would face as trial lawyers and trial judges if we had to prospectively deal with all of these events that may or may not occur? So I think the court in this case looked at the fact that these policies were going to end and decided based upon length of marriage, the work that the wife did in the marriage as far as taking care of the children, her subordinating her own career, that this was a permanent alimony case. And we always argued it was a permanent alimony case, even though I got involved in this case late in its kind of course of travel through the trial court. This was a permanent alimony case. It really was a question of how much. And I would suggest respectfully...
Well, let me ask you about that when we then get to the how much.
Okay.
When you deal with what the judge ordered and when he ordered it and what part of it was retroactive, Going forward, it's $10,000 a month, correct?
Yes, sir.
There was a period where it was $4,500 a month, and that wasn't altered by the court, right? The 10,000 didn't go back through the 4,500 time period because he was paying for the two houses, et cetera.
For part of it. The court ordered retroactive alimony for part of the $4,500 period. So once the Minnesota home sold, then retroactive alimony went back to that $4,500, and she got
totaling 4,500 or totaling 10,000?
She got $5,500 a month in retroactive alimony after the Minnesota house sold.
Okay, and before the Minnesota house sold, what she got was $4,500 total, correct?
Correct.
And for the first 12 months, she apparently got $6,000, right? Because she got the $4,500 retroactive, and she received $1,500 in cash.
Right. Well, she received $1,266 in cash, and she received some insurance
Was there
payments.
some reason why she would be entitled to $6,000 at the front end, but then only $4,500 after 12 months before the house was sold and it jumped to $10,000?
The rationale is found within the financial affidavits of the wife. The wife's financial affidavits, and the court ruled that her needs were not being met by either the $1,266 or the $4,500 during the course of this almost 4 years worth of
Okay,
litigation.
but the court decided $4,500 was enough for part of this time, right?
Well, but she didn't give credit for the $1,266. So I think you have to read into the decision that she found that she needed more than just the $4,500 for that period of time that the retroactive was awarded.
After the $1,500 stopped, and before the house was sold, was she getting any more than $4,500 a month?
No, that's the temporary order that was entered by Judge Turner.
And when the case was done, did the judge order anything more than $4,500 during that time frame?
No, there was a time period when it was just $4,500.
So, was there some change in financial circumstances from the first 12 months to the time where the judge said $4,500 a month was adequate to say that $6,000 was adequate for the first 12 months?
There was a substantial increase in what the wife's expressed needs were in her financial affidavit from the first financial affidavit that reflected about $6,000 a month in need to this, when the second and thirds were filed, when it was some $12,000 or $13,000.
Now, I'm asking whether there was a greater need during the time she was getting the $6,000 effectively to the time that it was dropped to $4,500 and the trial judge found $4,500 was adequate.
During part of that time it was, because remember that during part of that time the wife was displaced from the Merritt Island home and was actually living in some sort of extended stay
And that was
motel
during the
here.
12-month period that she was getting the $1,500?
That's my recollection, Judge.
Let me ask you about the life insurance question.
Okay?
What is the standard we should apply in deciding whether or not life insurance should be required?
It should provide adequate security to the former wife to ensure that if the husband passes away, she will be supported commensurate with what the alimony rule was, or order
Is there case law that says it's really just to avoid somebody being put in dire economic circumstances?
Well, that's exactly what would happen here. I mean,
Given your standard, which is so that she can maintain the standard, that would say every case should require life insurance, wouldn't it? Because the only way she can maintain her standard, assuming that the permanent alimony is appropriately granted, would be if it continued. So wouldn't that say every case was a life insurance case?
it would certainly suggest that, Judge.
And do you
and
think
not
that's the
every
proper
case-
law, that every permanent alimony case should also be a life insurance case?
The vast majority, yes. All, no.
What's the measuring stick? How do we determine whether a
Well-
case is or is not a life insurance case?
I think you have to look at in this case, the vast difference between husband's income and wife's, the long history of the husband's income being a multiple of 7 or 8 times what the wife's income is, and decide whether or not the existing, and in this case, this is not an order saying go procure life insurance, whether the existing life insurance policy should remain in force. If you look at the financial affidavits husband filed, one of the financial affidavits, I believe it's the first one, reflected 0 amount of premium for his life insurance, because the policies that we put into evidence in the joint exhibit notebook, H1, 2, 3, 4, and 5, all provided for in the event of disability, premium ceased. So in this particular case, you've got life insurance that in the other two affidavits reflected $300 a month in payment and $500 a month in payment. Those policies reflect $1.1 million worth of death benefits. There was no good reason in this case for the court not to award life insurance to support the alimony. Mr. Wayne's own exhibit, which was in Joint Exhibit H8, said that he had $1.85 million worth of life insurance death benefits. That was a document that Mr. Wayne created shortly before this case got filed. So there was ample evidence that there was a lot of life insurance available in order to secure the alimony. And if you look back at the course of this, particularly the last 12 or 15 years of this marriage, it was Mr. Wayne's income that provided for what the court described as an upper middle class, if not extravagant lifestyle that this couple lived. So I would suggest that the court was well within her discretion in determining that there should be life insurance and the amount of life insurance that was awarded in this case. Again, there was no requirement the husband go out and get any more, and it appeared that it was a de minimis amount in this family's lifestyle and income that was required in order to maintain that.
Opposing counsel said his strong argument is imputation of income. That he indicated that was his strong argument. You want to respond to that?
I would read Mr. Galt's cross-examination.
Pardon?
I would suggest the court read my cross-examination of Mr. Galt. Mr. Galt's testimony was awful. I mean, that's not a legal term, but he couldn't really identify any job. Remember, the standard here for imputation of income is that you have to find first as a trial judge that my client is willfully underemployed or unemployed. There was no evidence of that at all. There was hours of testimony at this trial about what Ms. EINSPAR did in order to try to find work to increase her income. I mean, this was a woman that for a large period of the time during this litigation was pretty close to being destitute. I mean, there was $1,266 being paid. She was forced out of her own home as a result of Mr. Wayne moving his new paramour into the house. And so she spent a lot of money. I mean, I was the fourth lawyer in this case. There was a lot of legal fees incurred. It took months in order to get the temporary relief order that was entered in May of 2013, just putting her at the $4,500 level by my predecessors. So we don't have the first standard, which is, was she willfully underemployed? We don't have from Mr. Galt any specific, here's a job available that fits your skills and abilities, and you can go get this job simply by going out there and asking for it. And we didn't have any testimony. I asked him repeatedly, cross-examination, can you identify, he points out a particular job. Well, what are those jobs' requirements? I don't know. Well, did you call anyone and find out what those requirements were? No, I didn't. Do you know whether Ms. Wayne has the aptitude or the ability to take this job? There was no vocational testing done. He had never met her. He had never spoken to her. He came into the courtroom and he testified, well, I think she can make $70,000. He didn't even, in cross-examination, he wouldn't even agree with me that her age, as asked by Judge Cohen, or her gender would have any effect on her employability at all. He refused to even acknowledge that. So I don't find, as the court found, he was just not credible about what other employment was available for him.
And just a couple other questions I originally broached with opposing counsel. It has to do with the $1,500 that they alleged that should have been credited that were not. And I think he indicated it was either for 11 or 12 months. Do you want to briefly respond to that or not?
As I indicated with Judge Palmer, I think the court was correct in not giving a credit for that because even with the additional $4,500 in retro that was awarded, the retroactive alimony that was awarded, it didn't meet her stated needs as reflected by the court's findings or by her financial affidavit. My calculation of that was a little more generous than what Mr. Feinberg's was. I had that the total amount of credit would have been from about 13 months at $1,266 if the court was going to give that, which was a figure of 16.
The record's really not clear on the number of months, but we know it was something like 1,500, and then there was another figure that was thrown out, 1,200 and something.
Judge, I have from March 12th March of 2012 until April of 2013 that the 1266 was paid. That was the best I could get from the record because it was conflicting testimony.
Would you address the car loan and the student loan?
Student loan, car loan were primarily in the son's names, but just guaranteed by the wife in one
Contract.
case.
It was a contractual assumption of liability by both parties for the loan, for the car loan and for the student loans, correct?
I would agree.
So why isn't that a marital asset, or marital debt, rather?
Well, the reason I think the judge didn't find it to be a marital debt is
I'm saying legally. Why wouldn't legally that be a marital debt?
because it was a primary loan in the son's name. Even though
There's a contractual obligation incurred during the course of the marriage.
under 61075, that would be a marital debt.
Okay. So the trial court erred in not finding it as such.
Probably. Can we talk about credits for just a minute?
And also, go on to your cross appeal.
Yes. So let me talk about the credits that were given. As the court's probably aware, $274,754.35 were given as credits concerning payments that were made by the former husband on the Hillaway property, a life insurance premium payments or a series of payments, and then taxes and insurance on the Merritt Island property. That resulted in a swing in equitable distribution of $137,377.18 against my client. Judge Cohen, you wrote in Moti, as the author of that opinion that was cited in our brief, that when one of the spouses is typically and traditionally the source of the income for the parties, that credit shouldn't be given for payments that are made during the course of the litigation. That certainly is the unrefuted testimony in that case. There are a couple of other cases, the Cortese case we cited and Netsch, which also set forth that proposition, that credit shouldn't be given when there's such a difference in income within the party's household up until the time when the divorce is started. And I think the court, I would respectfully suggest that the trial court erred in giving those credits in this particular case.
What's the standard of review on that issue?
It would be an abuse of discretion.
And why is this an abuse of discretion?
Well, because if you look at both your opinion in Moti and the other opinions that we cited in our brief, there isn't any conflict at all in the record that it wasn't all of Mr. Wayne's income that allowed the parties to acquire the houses upon which these payments were made. The wife alone, clearly, even with her income that she was making after the divorce started, would have been unable to acquire two properties in value of excess of $2 million with loans in excess of $2 million. And so all of that debt was created as a result of the husband's income. And I would suggest in this particular case there was an abuse of discretion based upon that unrefuted testimony that it was his income that allowed them to do this. Does the panel have any other questions?
There was a question about how much life insurance was in place, and I think there was an argument whether it was 1.1 or 1.8, and I think the court ordered 1.8. Is that correct?
Yes, that is correct. And if you look at, again, going to bore you with some detail in the joint exhibit notebook, H1 through 5, it's 1.1 if you just look at the policies. It's the husband's statement under H8 of the joint exhibit notebook that has the 1.85. So either the husband was wrong when he made out his little chart of what the life insurance was immediately prior to the divorce starting, or we left out a life insurance policy when I put together our joint exhibit notebook.
Okay. I understood there may be some term policies and some whole life policies, and that's how you get to the 1.8. Is that right?
I can't answer that. I looked back through all the policies. I read them yesterday and tried to get ready for today. And whether it was term or life, I added up the policies we put into evidence. It was 1.1.
Well, what should the standard be in determining how much life insurance to require?
You know, that's an interesting argument that we deal with a lot. There's an argument to be made that there should be a declining balance in the life insurance death benefits that are available as the alimony, especially in a durational case, as the alimony goes down. This, we don't have that. I mean, we don't have a durational case here. We have a permanent alimony case. So it's really based upon what's life expectancy. We know that Mr. Wayne has MS. We know that he's male, so he probably doesn't have the same life expectancy that Ms. EINSPAR has. So the court has this kind of broad discretion of, let's try to figure out if she's life expectancy of a Caucasian female is 84 or 82, I need to have enough to secure continued support until that age. We had a lot of conversation in this case about Mr. Wayne's health issues, and there was actually some testimony about his shortened life expectancy, I think from Mr. Price, who was an accountant that testified. So I think the court was within its discretion in its ruling. Thank you.
Yes, sir. All right, you got just under 5 minutes.
On the issue of credits, Your Honor, the cases that we're relying on are cited in our brief. For the record, there's a pretty long line of law in Florida. We cited the Cortez case, which is out of 2011 from this court, 5th District, authorizing credits. We also cited Fairchild versus Fairchild, which is out of this court from 2014, which addressed credits for payment of marital liabilities during the pendency of the divorce proceedings. And we also cited the Heine versus Heine case from the 2nd District, which is from 2013. And all of those cases talk about credits for payments of marital liabilities and obligations during the pendency of the case. The appellee in this matter on cross appeal has cited cases to the court talking about primarily payment of household expenses, the mortgage on the marital residence where the wife and the children are residing. These cases are very different in nature. They talk about what do we do with all of the other marital liabilities besides the marital residence. These cases talk about investment properties. They talk about investment properties in different states. They talk about all of the kinds of things that husbands and wives get into during the course of a marriage. When a divorce is filed, who pays them? And I disagree with counsel's comment in response to Your Honor Cohn's question about the standard of review. I think the trial court under 61075 is obligated to identify every marital asset and every marital liability, except for those de minimis ones, which we can exclude. And the failure to do so is reversible error. And the Heine case says it. Boy, I feel like I'm competing with, I don't mean to shout, I'm competing with the rain.
It could be worse. It could be leaking on you.
Okay, I'll give you that one. The Heine case says it best. It says a trial court's failure to include all marital assets or debts in equitable distribution violates 61075 and requires reversal. It is reversible error for a trial court to fail to identify and distribute each marital asset and liability. The payment on these things during the pendency of the course is also a marital liability. The trial court gave credit for the floating of the Minnesota property, the Hillaway house, for the entire course of this case until it's sold in March of 2014. Why the trial court didn't give credit for the payment by the parties of the auto loan, I don't know. Why it didn't give credit for the payment of the student loans, I don't know. I think the trial court got it right in terms of the credits based upon these cases that we've cited in our brief, but got it wrong when it didn't include the student loan, the car loan, and equitable distribution as marital liabilities, and didn't give Mr. Wayne credit for the payments that he made on those loans during the course of the proceedings.
How much life insurance did your client have? Is it 1.1 or is it 1.8? And did he represent somewhere that he had 1.8?
The answer to the last question is yes. I believe his testimony was 1.8. I agree with Mr. Peters that if you look at the joint trial notebook that Mr. Peters' office put together and we submitted into evidence as a joint exhibit, it says 1.1. And to follow up, Justice Palmer, on the life insurance issue, you asked a couple of questions about that. I would bring the court to this court's opinion in Sweeney, which is only 4 years old. It's from 2013. It's cited in our brief. And it says, "This court and other districts have held that such security is justified only if there is a demonstrated need to protect the alimony recipient, such as when he or she would be left in dire economic straits upon the death of the payor former spouse." That opinion also cites this court in a case called Lapham that is cited in our brief as well. And in Lapham, this court noted that cases upholding such security included those in which the recipient was disabled, elderly, or had such limited employment skills that the death of his or her former spouse would cause that person to rely on welfare or the generosity of others. And there's a litany of cases all over the state of Florida that tracks that language. And in this case, Ms. EINSPAR, the wife in this matter, left this divorce with just under $1 million in net assets, and even without an imputation of income, has the ability to earn $40,000 per year. That's what she's earning at her job in Pacer, and the record reflects that. So the issue would be, is that somebody who's impoverished?
All right,
And I would
thank you.
suggest it's not.
Thank you, Counsel.
Thank you.